We're now ready to begin Unit 4 on contract performance and evaluation. This is basically the end game of the contracting process. And we're going to be dealing quite a bit with the way you resolve disputes in completing performance of the contract. If you don't have disputes, then there are really no great issues to discuss. And that's the case with many contracts. You negotiate, you sign a contract, you perform, and that's the end of it. So nothing to discuss there. But if you go down the alternative path where there are problems with payment, with delivery, with quality, etc., then you need some clear processes for dispute resolution. And we introduced dispute resolution earlier with what we called ADR, Alternative Dispute Resolution. And ADR is especially important for non-lawyers for a number of reasons. First of all, with almost every business contract today, you're going to be negotiating ADR contract clauses. And it's amazing how many business people will negotiate a mediation clause or an arbitration clause without really understanding what they're agreeing to. So as a result of our discussion during this unit, I want you to walk away from this unit with a clear understanding of what you're negotiating and whether you should be negotiating it at all. Second, ADR is important because you're going to be a participant in ADR processes if you become involved in a business dispute. If there is a performance problem, you'll be involved in an ADR process of one sort or another. Therefore, it's important to understand what these processes are. And finally, it's important to understand ADR because often you will be the third party in resolving a dispute. You will be the arbitrator. You will be the mediator in resolving everyday disputes, whether they're family disputes between your children, for example, or whether you're working as a manager in a business and you're resolving disputes between people working in the business. So this coverage is especially important for a variety of reasons. And yet another reason is that often attorneys are not all that enthusiastic about ADR. Here's a very almost shocking statistic that 1/3 of lawyers surveyed in some recent research never advised their clients to try mediation or arbitration. So often the burden will be on you to suggest this. I'm not exactly sure why more attorneys don't advise ADR, but part of it might be economics. Here's a clip from an article in the Wall Street Journal about a law firm who is having revenue problems. And it mentions that they had a big problem with revenue because 3 of their cases settled. And as a result, they lost $35 million in revenue. So I'm not saying that they were against the settlement, but yet the economic motivations of lawyers might lean more toward continuing litigation as opposed to settling. So in discussing the end game, we're going to start by looking at dispute prevention, which actually peels the onion back a little bit further than ADR. We're saying that before you even get to a dispute, are there ways that you can use to prevent the dispute from arising at all? And then we'll look at ADR concepts very generally. I then want to give you some management tools, very practical tools that you can use for resolving disputes. And then we're going to look at the 2 cornerstones of ADR in a little more detail. We're going to look at arbitration and mediation. And finally, I have some suggestions for what you should do after you finish performing a contract in terms of reviewing it, reviewing what happened, and evaluating. So let's move to dispute prevention. And dispute prevention or preventive law is something that's been kicked around for years, but only within the last few years has a clear definition been developed. And basically it means that it's more important to predict what people will do than to predict what a court will do. Winning a lawsuit can be ruinous. In the past, the emphasis was on, well, if they sue us, will we win or lose in court? That was the traditional question. The preventive law question is not, will we win in court, but what is driving people to court? And this preventive law philosophy was well captured by the philosopher Voltaire. I was ruined twice in my life, once when I lost a lawsuit and once when I won one. In other words, even winning a lawsuit can have disastrous consequences, not only in terms of the legal cost of the proceedings, not only in terms of any damages you have to pay, but also in terms of destroying business relationships. So, let me give you an example, a personal example, of a company that I think does a great job with preventive law, and that's Marriott Corporation. Marriott Corporation has been written up in books like In Search of Excellence about how responsive they are to customers. And I had a personal experience a number of years ago. I was invited by a corporation in Texas to give a one-day legal briefing. So I flew to Dallas and checked into my hotel, and I called the front desk and asked for an early morning wake-up call. Well, the call never came. Now, being a very risk-averse person, I had set 2 backup alarms, so I woke up at 6 a.m. as scheduled and got to my briefing on time, no problems. But when I checked out, I thought I would test the Marriott dispute prevention system. I filled out one of the little cards that they leave in your hotel room asking, how was your stay? And basically I said, I had a great stay, enjoyed the stay. The problem is I never received my wake-up call. Well, after returning home 2 weeks later, I received this letter from the president of the Marriott Corporation, J. Willard Marriott. Let me read what he said. He says in this letter, Dear Mr. Seidel, now he misspelled my name, but that's not a big deal. Everybody does. It was truly disappointing to learn about the problem you had with our wake-up service. Please accept my sincere apologies. I have forwarded your comments to our Dallas-Fort Worth Airport Marriott and have asked our general manager to give prompt attention to the matter. Thank you for taking the time to write. I hope you will allow us another opportunity to serve you soon so that we may regain your complete confidence. Sincerely, signed, Bill Marriott. Now, this may have been Bill's computer speaking. I'm not sure. It may have been an automated response, but it gave me a good feeling about my stay at the hotel. Now compare this dispute prevention approach with another situation involving another hotel. We have a prominent entertainer by the name of Connie Francis. Back in the 1960s, she was an international star. She had many hit recordings. Had a very tragic situation in the 1970s. She was staying at a Howard Johnson hotel, and somebody broke into her room and raped her. And this was her response to what happened. I never received so much as a note from Howard Johnson's saying, we're sorry it happened. After being shocked, I was very angry. Now, let's try to guess what happened in this situation. And my guess is, after she was raped, of course, the news would reach Howard Johnson's headquarters. And so the company leaders, probably the board of directors, probably met with their attorneys. And they said, what should we do here? Should we apologize to Connie Francis? And my guess is probably the lawyers would follow the traditional approach. They would say, well, number one, if she goes to court, she's probably not going to win. This was not a result of our actions. This was a result of an independent third party, a criminal, and therefore we should not be liable. In other words, probably they took a traditional approach. What happens if somebody goes to court? And then they probably also said, whatever you do, don't communicate with her, don't do anything that might indicate that we are liable, such as an apology. Well, what happens? They don't apologize for what happened. Connie Francis is shocked. She's angry. She then goes to a lawyer. The lawyer sues Howard Johnson's. There are years of very negative publicity as this case works its way through the court system. And at the end of the day, Howard Johnson's has to write a check to Connie Francis for $2.5 million. And perhaps all of this could have been avoided with a dispute prevention philosophy. Now, I did read about another hotel recently, or actually somebody told me this story, that tried a dispute prevention philosophy but failed. Apparently, a large company scheduled a corporate retreat at the hotel, and they had major problems with cockroaches in the hotel. So the person who organized the retreat sent a very nasty letter to the hotel manager complaining about the cockroaches. And almost immediately, he received a detailed 4-page letter apologizing and going into great detail about what the hotel was going to do to eliminate the cockroaches. And this corporate manager was very impressed until he got to the last page of the letter, and a little yellow Post-it note floated out from the last page. He picked it up, and it said, "Sarah, send the son of a bitch the bug letter." So sometimes companies have trouble implementing a dispute prevention philosophy. Let me give you some data and another example of dispute prevention. This happens to be a local example involving the University of Michigan health system. The traditional approach when doctors were sued was you don't apologize. You don't talk about what happened. Much as in the Connie Francis case, doctors were advised, don't apologize to patients, don't talk to them because we don't want to do anything that would create liability. Well, the Michigan hospital system decided to take the opposite approach. They adopted what they call the Michigan Claims Management Model, and it's based on disclosure. We're going to disclose what happened to our patients. We're going to apologize if we've done something wrong, and we're going to offer a settlement. And the 3 principles underlying this model is we want to compensate patients quickly and fairly if there's been unreasonable care. If the care was reasonable, then we want to support our hospital staff, and we want to learn from patients' experiences. We want to improve our processes, which often didn't happen under the traditional model where hospitals refused to acknowledge that something was wrong. So what's the result? The lawsuit rate at the Michigan hospital system dropped from 2.13 per 1,000 patients to 0.75. The median resolution time dropped from 1.36 years to less than a year. And they accomplished the real goal, which is to improve patient safety and to do what is right. Social media provides a lot of opportunity to engage in dispute prevention. And here's one of the pioneering social media efforts. We've got a person who's called Comcast Twitter Man. When Twitter first started to become popular way back in 2008, one of their customer service managers, Frank Eliason, realized how powerful this could be. So beginning in early 2008, he began searching Twitter for the word Comcast, or he also searched for Comcrap, to discover what people were saying about the company. And by the end of the year, he had handled 22,000 tweets, and he was able to respond to the customer concerns. So for example, we've got this person, Technophile, who posts this tweet. We have the Comcast service guy out, and he tries to charge us for new cable. Then he leaves, and not only is our cable out, but also the internet. So Frank looks into the situation, contacts the guy, gets details, and discovers the problem is probably the exterior of the building, sends a technician, and now the customer is friendly. So through social media, he has used a dispute prevention philosophy. But even with social media, problems might arise. Here's a recent situation. Somebody posted on Facebook, a Domino's pizza customer, "Hey, this is the best pizza ever. Keep up the good work, guys." Domino's response, "So sorry about that. Please share additional information with us. Please reference this number so we can have it addressed." So you have to be careful about sending standardized responses to social media comments. So that concludes our look at dispute prevention. We're now going to move on to discuss ADR, Alternative Dispute Resolution, concepts. This is a general introduction and look at concepts, and then later on we're going to look more in depth at the two key building blocks of ADR, which are arbitration and mediation. So in this segment, I first of all want to give you an example of a form of mediation, and then we'll look at an example of a form of arbitration. But the basic message here is that you can start with the two building blocks that we'll explore later on, but you can be as creative as you want to be in developing variations on the two basic themes. So let's start with mediation, and the example I'd like to give you is called a mini trial. But again, there are a lot of variations on the basic mediation theme. So here's the example. Let's take a look at an actual mini trial. This was one of the very first mini trials ever. It involved an intellectual property dispute between Telecredit and TRW. And this case is typical of a lot of litigation. The two parties fought over intellectual property. There was a $6 million claim. The parties spent $500,000 in the early years of the litigation. They exchanged 100,000 documents. The case sat in court for 3 years. Nothing was happening. And so finally, the executive vice president of TRW and the president of Telecredit got on the phone and basically asked, why have we outsourced this dispute to the court system? Why have we outsourced it to lawyers? We deal with business problems all the time. Why don't we get together and just resolve this dispute? And so they came up with a structured negotiation, which later came to be known as a mini trial. And fundamentally, there were 5 people at this structured negotiation. There was the executive vice president of TRW, the president of Telecredit. They each brought an attorney, and then there was a neutral party, an expert on intellectual property, who could answer any technical questions that arose during this negotiation. So they began on day one with the attorney, one of the attorneys, let's say the attorney for Telecredit, standing up in front of the two executives and explaining her case. And then the executives asked her questions. If there are technical issues, they referred them to the intellectual property expert, and that attorney sat down. And then let's say the attorney for TRW got up and again had about a half day to present the case, answer questions, technical questions go to the expert. That person sits down. The two executives then go off into a room by themselves, for 1/2 hour and settle the dispute. Estimated savings in legal fees, $1 million. But think about the benefits beyond those dollar savings. For one, this procedure gave each executive a chance to hear the case as described by the opposing attorney. And that description might sound quite a bit different from the story that they get from their own attorney. Second, they're able to come up with a resolution of the case that makes sense from a business perspective. When you're in court, litigation is a zero-sum game. One person's going to win $6 million, one person's going to lose $6 million. But when you negotiate a settlement as somebody in business, then you can come up with something that preserves the business relationship. So that's a quick example of a form of mediation. Again, you can come up with as many varieties as you want. Let's now move on to arbitration and an example of a variation on the arbitration theme. This example is called Rent a Judge. Now, this is not the same as the Buy a Judge program that has been used in Chicago and other emerging economies for many years. Just kidding. With Rent a Judge, you actually hire a retired judge to hear the case. And so, an example. We've got a couple of former roommates who are involved in a dispute, Brad and Jennifer. Jennifer is especially upset because Brad now has a new roommate called Anjali. So they're involved in litigation, Brad Pitt and Jennifer Aniston. And rather than go to court, they use the Rent a Judge procedure. They hire a retired judge to hear the dispute. Now, what are the advantages for Brad and Jennifer in using this retired judge? And what would be the advantages for you if you're involved in a business dispute? Think about that for a second. Hit pause if you want. Write down the advantages that you can think of in using this form of arbitration or other forms of arbitration. Here are some items that might be on your list of advantages. Number one, it might be a lot quicker than sitting for years in the court system waiting for your case to arise. Number two, it might be cheaper, although we're going to discuss that issue later. Number three, and this is a big one for Brad and Jennifer, but also for your business. You want to keep the dispute out of the newspapers. You want to keep this private. One way to think about arbitration is that it is a type of litigation, but it's private litigation. And finally, unlike the regular court system, you get to pick the judge. When you're in the regular court system, the selection of the judge is pretty random. You might end up with a judge who has never handled a business case, who has no idea what's going on in the type of business dispute that you're involved with. With Rent a Judge, you can pick somebody who's an expert in the particular area that is in dispute. So lots of advantages to using that form of ADR. One additional point, and this is something we talked about earlier when we had the brief introduction to ADR at the beginning of the course, and that is the ADR processes, which are arbitration, mediation, and negotiation, can be used not only for dispute resolution, but also for doing deals. And this has been a dramatic change over the last 10 years or so, where many more third parties are involved not only in resolving disputes, but also in making deals. Here are some results of a recent survey of mediators. 40% of the mediators were involved in deal making. The deals they were involved in ranged from 100,000 to 26 million. And here you have some examples of the types of deals that where the negotiators brought in third parties. You can use not only mediation, of course, but also arbitration. One area in the United States where arbitration has been used for several years is in professional sports, especially baseball. So here's an example of baseball arbitration. We've got a pitcher by the name of Roger Clemens who retired, and then he came out of retirement to pitch for Houston, and they paid him $5 million. Well, as it turned out, he had a great year. He was named the best pitcher in the league, won the Cy Young Award. So when it came time to negotiate his salary for the next year, Houston asked Roger, well, what do you want to be paid? And he wanted something a little bit higher than $5 million. He basically looked at the number on his uniform, and that said 22. So he said, well, I want 22 million. Houston countered with an offer of 13.5. Now, this is the kind of dispute that often goes to arbitration. This is the kind of negotiation that often goes to arbitration, although in this case they settled. But in baseball, they use a unique form of arbitration that you could also use, and that is, rather than having the arbitrator select the salary, each side privately submits a number to the arbitrator. And then the arbitrator has to pick one of those two numbers. So, for example, if you were working for the Houston Baseball Club, what number would you submit? Again, privately to the arbitrator. Think about that for a second. What number would you submit? Logically, you should have picked a number that was larger than 13.5. You want to pick a number that you hope will be reasonable to the arbitrator, which will be somewhere between 22 and 13.5. You don't want to lock in on 13.5 because if Roger budges, if he, say, changes from 22 to 20, then the arbitrator might select that number. So you want to pick a reasonable number that the arbitrator will select. And so it's going to force both parties to come in with numbers that are closer to the middle and more reasonable. So that concludes our look at ADR concepts. We're now going to discuss some alternative dispute resolution tools, some very practical ADR tools that you can use in resolving disputes. And specifically, we're going to look at these 4 tools. First of all, the corporate pledge, then we'll look at screens, and then contract clauses, and finally, online dispute resolutions. The corporate pledge is a pledge that you can adopt, or your company can adopt, as a matter of corporate policy. This pledge has become very popular. It's been adopted by over 4,000 operating companies as a matter of corporate policy, probably adopted at the board of directors level. And this document is a little bit difficult to read, but the key language in the document reads as follows. In the event of a business dispute between our company and another company which has made or will then make a similar statement, we are prepared to explore with that other party resolution of the dispute through negotiation or ADR techniques before pursuing full-scale litigation. One especially useful feature of this pledge is that I think it helps avoid the psychological trap that we discussed earlier in the course called reactive devaluation. If you're in the middle of a dispute and you come to the other side and you say, well, let's try going to mediation to resolve the dispute. Your proposal might be devalued by the other side simply because you're making it, and they might view this as a sign of weakness. But instead, if you go to the other side and say, look, this is our long-established corporate policy. Our board of directors has adopted this pledge as a matter of policy. Will you consider also adopting a similar approach so that we can proceed to mediation? Then I think your proposal will carry more weight and perhaps avoid the reactive devaluation trap. So let's take a look at screens. Screens are basically a list of questions designed for people in business, non-lawyers, and based on the answers to those questions, the screen will advise you, for example, whether to use a binding ADR process or a non-binding process. Now, quick question, you should be able to answer this by now in the course. What do we mean by binding processes, and what do we mean by non-binding processes? Hit pause or just take a second to write down your answer. What is a binding process and what is a non-binding process? The non-binding processes are negotiation and mediation. When you enter into those processes, you're not bound to anything, as opposed to litigation and arbitration, which are binding processes. So basically, the way screens are used, you first of all will answer these questions, and then the screen will advise you to use either the binding process or the non-binding process. And if it advises you to use a binding process, then you use another screen that will advise you whether to use litigation or arbitration. So, very useful tool for managers. Contract clauses are very important. And in determining whether to use an ADR clause, there are two basic scenarios. The first scenario is where you include the clause in a business contract. And I've never seen empirical studies, but I think that this by far is the most common use of ADR contract clauses. The second possibility is not to include the clause in a contract and wait until a dispute arises. This is a little more dicey because once you're in the middle of a dispute, it's going to be more difficult to persuade the other side to agree to mediation or arbitration. So it's better, I think, to bake it into the original business contract. And there are a variety of clauses that you can use. You can find these easily on the internet. One possibility is to simply state in the contract, we agree to go to mediation in the event of a contract dispute. Second possibility is simply we agree to go to arbitration. But then you can have an escalation clause where basically you say, we agree to go to mediation first, and if the mediation fails, then we will move to arbitration. Or you can have a three-part escalation clause. We're going to start with negotiation. If that fails, we'll move to mediation, and if that fails, then we will move to arbitration. So lots of possibilities, and again, you can find many examples on the internet. Finally, there's increasing use of online negotiation and dispute resolution. There's been a pile of research on whether using online resolution is effective or not. I've got a huge stack of research studies. I've tried to summarize the pros and cons of using online negotiation and dispute resolution. And you can see here some of the basic conclusions, a lot of reasons on the left-hand side to use online negotiation and dispute resolution, a lot of reasons on the right-hand side not to use it. I think these are fairly self-explanatory, but I think the bottom line on the right-hand side is that online negotiation and dispute resolution is less effective. However, the bottom line on the left-hand side is it's cheaper and more convenient. It's a lot cheaper to use online than flying to various locations and having face-to-face meetings. One compromise that you might consider is that one of the reasons why online negotiations are not as effective is that it's more difficult to build rapport. That's the very first item under con, hard to build rapport. Earlier in the course, we emphasized how important it is to try to get to know the other side before you dive into the details of a deal. So one possibility to think about is there some way that you can develop rapport at the beginning of a negotiation, especially through the use of a face-to-face meeting, and then you can move to the online negotiation and dispute resolution after developing a relationship with the other side. Here are some examples of online dispute resolution. Some of these involve everyday situations. Landlord bills me and my roommates for damages we didn't cause, broken window, broken screen. We live in a bad neighborhood. The landlord insists we caused the damage and that it had to be us. So we've got basically a dispute between landlord and tenant. Another online dispute is a little more exotic. Person wants a Harley Davidson tattoo on his left bicep. Problem is the tattoo artist misspelled Harley Davidson. According to this person in filing this complaint, this is a permanent typo. I either take a belt sander to my arm, wear long sleeve shirts for the rest of my life, or this person has to pay to have the thing lasered off now. So that's the tattoo dispute. And then some of these disputes are fairly romantic. Here's an example. For the last year, my boyfriend of 3 years and I have been having sex using only the pill for contraception. I want him to pay half the cost. He refuses. I'm asking the jury to resolve this before it becomes ugly. We agreed to let you decide. I'm suing him for $11.75 per month for as long as we are sexually active. So examples of online dispute resolution. And that concludes our look at ADR tools. We're now ready to begin our look at the two building blocks for all of ADR, arbitration and then mediation. So let's start with a question. Have you ever been involved in an arbitration? Or more specifically, the question is, have you ever signed an arbitration agreement? Think about that for a second. Answer yes or no. If you answered no, that means that you have probably never purchased auto insurance. That means you've probably never used a credit card. That means you've probably never used eBay, never used Amazon, never purchased anything on Amazon. Because if you've done any of these things, you have signed an arbitration agreement. In other words, arbitration is embedded in a lot of our everyday transactions. That's the fine print that you and I never read when we sign up for a service. Here, for example, is the Amazon agreement that you agreed to if you use Amazon. What is actually involved in an arbitration? I think the best way to look at that and analyze it is to look at a video of an arbitration. This is a 15-minute video. It's going to be a little complicated at the beginning, so let me give you a very quick briefing. What we have here is a dispute between the owner of some real estate and a contractor. The owner hired the contractor to build a building. Problem is, after the construction started, the owner made some design changes. And as a result, the contractor is claiming an additional $55,000. Also, there's a subcontractor involved who did some plumbing work hired by the contractor, who also had to make changes, and these cost an additional $95,000. So the owner has refused to pay, and this matter is now in arbitration. As you look at the video, please keep these questions in mind, which I want to address after the video. First of all, if you were the arbitrator, how would you decide the case? Second, are there any surprises in the arbitration? Is this what you expected from an arbitration? Third, does the arbitrator have to be a lawyer? Fourth, do the parties, or would you have to be represented by a lawyer in arbitration? And finally, is litigation procedure followed in arbitration? So please think of those questions as you watch this video.
Didn't you tell me that the arbitrator's a lawyer?
Mm-hmm.
I'm concerned that he won't be able to understand what I'm trying to say in there. And that could jeopardize the whole arbitration.
Yeah. And what I understand is that you want to make sure that we have an arbitrator who's knowledgeable about construction.
Yeah.
I agree. Mr. Halbrand, though, he's well qualified in that regard. He was educated and he worked as a construction engineer before he ever became a lawyer. And his law practice has been concentrated in construction. And he is an experienced arbitrator. So that's why we put him #1 on the list of potential arbitrators that the AAA gave us.
Well, as long as he understands construction, I feel comfortable.
Good morning, everyone. I'm Steve Van Leer, the American Arbitration Association's tribunal administrator on this case. It's nice to meet you all face-to-face after talking so many times on the telephone. You've all met David Heilbronn, the arbitrator, so at this point I'll turn it over to him. Mr. Heilbronn?
Thanks very much, Steve, and good morning to everybody. I understand that the subcontractor has a claim against the contractor, and the contractor has a claim over against the owner. I've read each of the claims and the answers to them, so I'm generally familiar with where we're all starting from. I also understand that the subcontractor has a contract with the contractor has a contract with the owner, and that each contract has in it an arbitration agreement. But that since all claims arise out of the same set of facts, everybody's agreed to arbitrate both claims together. So thanks for that, and we are ready to go. As you know, this is an informal proceeding. The formal rules of evidence do not apply, and the basic rule is just common sense. So you should stick to the point and the facts that count, so we get to the meat of it all quickly and we move along. And I know you'll all do that. Now, I understand last that each of you has an opening statement that tells your view of the case, and that'll be very helpful. So Ms. Crittenden, for the subcontractor, if you'll start first, the claimant, and then the contractor, Mr. Madison, and finally the owner. We're ready. Please proceed.
Thank you, Mr. Heilbronn. As you know, I represent Mead Mechanical, the plumbing subcontractor in connection with this project. Mead Mechanical had a contract with the general contractor to install all of the plumbing fixtures in the building. We received a work schedule from the general contractor and were well underway in performing under the contract when we received a stop work notice from the owner as a result of design changes proposed by the owner. At that point, we got our crews off the project, got them into other jobs, and waited for the design changes to be delivered. Once we received those, it was apparent that we had to go back in and redo a lot of the work that had already been done. The cost of this additional work totaled approximately $95,000. Nevertheless, we went back in, we got the work done in accordance with the new plans and on time, and submitted our bill to the general contractor. From that point forward, we have received nothing but delays. We have not been paid. Apparently, the owner is taking the position that he is not responsible for these charges because none of the work would have had to have been redone if the original work schedule had been complied with. For his part, The general contractor tells us that he had the right to vary that work schedule, and in fact had the right to be ahead of schedule if that was necessary, and that he also discussed all of this with the owner before the design modifications were actually implemented. We don't really know or care whose position is correct. We simply want to be paid for the work which we have already done, and that is why we have initiated these proceedings.
Thank you, Ms. Crittenden. Mr. Madison, will you please call your first witness?
Yes. As our first witness, I'd like to call my client, Mike London of London Construction.
Mr. London, please raise your right hand. Do you solemnly swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you. Mr. Madison, please proceed.
Mr. London, would you please explain to the arbitrator the substance of your agreement with the owner, Mr. Baker?
Yes, it was not a complicated project. I agreed to build Mr. Baker's building for him. It was an office building for a lump sum price. My price was based on the plans and specifications that he furnished us prior to bid.
Did you begin the work?
Well, yes, we were given a notice to proceed and we started on the project right away with the foundations. Our subcontractor, Mead Mechanical, was also doing some of their preliminary work and their pipe chases, which are in the foundation.
How did the work progress?
Well, we were well into the subcontract and submittal phase, and we were in good shape with respect to our schedule.
Did any delay occur in the work?
Well, we gave the owner our schedule, and we were beating the milestones on that schedule when Mr. Baker called us on the telephone and told us to stop work because he was redesigning some of the work.
Mike, this is Bill Baker calling. I wanted to let you know that I've decided to make some structural changes on our building, and we'll need to stop work for a while till we get it straightened out.
Bill, you know that we've started on the foundations and the mechanical subcontractor has got some completed work out there as well. I think based on our job walk last week, Mead has about 35% of their rough-in done, and we're forming and pouring the first half of the grade beams. Anyway, I know that if any of your changed work affects the work already completed, it's going to mean some extra costs, and it's going to have to be for your account.
Well, Mike, the changes really shouldn't affect the work in place if it was done as the schedule shows. But in any event, if there's a problem, you let me know what the cost will be.
Oh, I will, but I'm concerned that if the redesign takes any length of time at all, it's going to mean a delay and extra costs. I've scheduled some heavy mechanical equipment to be delivered, and my labor agreements are coming up in June.
Well, I really don't think that we'll be held up too long, but in any event, you let me know, okay?
Okay, I will. It was almost 4 months since my conversation with Mr. Baker that we received the revised drawings and structural changes. Of course, we took the revised drawings and forwarded them to our subcontractor, Mead Mechanical. But the structural changes required a substantial amount of the plumbing and mechanical work, which had already been done, to be ripped out and redone. For instance, it required changes in the locations of the blockouts, grade beams, and so forth. It was almost 6 months since the owner told us to stop work that he ordered us to resume work. In addition to our subcontractor's claim, we incurred extra costs in the area of extra supervision and coordination of the work.
Well, would you please tell the arbitrator the costs that you incurred as a result of the 6-month delay and the changes that were made in the work?
I've prepared a record of our labor and material costs. It itemizes and breaks down our extra costs in the area of extra supervision, remobilization, and escalation. Not including Mead Mechanical's claim, our claim and extra costs amounts to $55,000.
Mr. Halbrin, as the contractor's next exhibit, I'd like to submit this summary of the costs that were incurred in connection with the delay and the changed work. I've already given a copy to Mr. Hogan, the owner's lawyer.
And I would simply like to note that this is only a record of claim costs and has no bearing on my client's liability.
Well, I appreciate that. I'm sure we all do. And of course, you can cross-examine to the extent you want with respect to the costs. Now, Mr. Madison, do you have any more questions?
I have no more questions of this witness.
Fine. Mr. Hogan, please proceed with cross-examination.
Mr. London, after you had begun work on this project, you were aware, were you not, that structural redesign was being considered by the owner?
Well, I seem to recall hearing something like that, but never anything from Mr. Baker.
Well, regardless of the source of these rumors, you were aware that redesign was being considered, correct?
Well, as I said, I heard rumors, but it was a long time after I first heard them that Mr. Baker said anything to me. In fact, I'm sure it was not Mr. Baker who first told me about the structural redesign.
Wouldn't it have been easy for you, sir, to call Mr. Baker and find out whether or not the rumors were true?
I suppose so.
Don't you think that you, as a prudent general contractor, had a responsibility to call the owner and find out whether redesign was being considered?
Well, I am a prudent general contractor, but I'm not an architect or an engineer. I simply build the project according to the plans and the specifications that the owner gives us, and it's up to him to make any changes that he wants to.
The work schedule that you have in front of you, sir, that is the one that you prepared and submitted to the owner in connection with this project, correct?
Yes, it is.
And this is the schedule that was submitted pursuant to the agreement between you and the owner for the construction of this office building, correct?
Well, that's what you say, but as far as I'm concerned, we were ahead of schedule.
You knew, did you not, sir, that the owner was concerned about the schedule and the time when the project would be completed?
Well, I knew that he wanted the building completed on time so he could start leasing the space and turning a profit.
Isn't it true, sir, that if this schedule had been followed, none of the work done by Meade Mechanical would have had to be redone?
Yes.
Thank you, sir. I have nothing further.
Mr. Madison, do you have any further witnesses to put on for the contractor?
No, Mr. Halpern, that's all we have at this time.
Thank you. And Mr. Hogan, are you ready to proceed?
Yes.
Then please put on your first witness and put on the owner's case.
Mr. Baker, please tell us about the reasons for the structural redesign work.
Well, the construction had barely gotten underway. I had a conversation with my architect who suggested some changes to the front entrance of the building which would have involved relocation of the public lounge areas. I liked the idea. It would have improved the attractiveness of the building, so I told him to work up a design. When he did, I liked it and I decided to proceed. I immediately called the contractor to let him know what was in the works. Hello, Mike. This is Bill Baker calling. We've decided that we're going to change the front entrance to our building, which may require moving the public lounge areas. Looks like you'll have to hold up any further work till we decide exactly what we're going to do.
Well, Bill, when we were out at the job last Friday, you saw that we had the foundations and some of the mechanical in place. I think that's ahead of my schedule that I gave to you. If you're going to start moving things around at this point, you know there's going to be some extra costs, and I'll have to submit them to you.
Well, I can see what you're saying, but as I read the work schedule, which of course you submitted, the work that you've completed so far, in accordance with the schedule, shouldn't have to be changed, and there really shouldn't be any extras.
Well, Bill, I'll have to take a look at it, and I'll let you know as soon as I can.
Well, okay, Mike, you check it, and if you think there are going to be any extras, you let me know right away, because it may change the way I go on this.
Well, I'll take a look at it, Bill. All right.
Did you ever authorize any extra work?
Absolutely not.
I have nothing further, Mr. Halpern.
Thank you, Mr. Hogan. Mr. Madison, would you like to cross-examine?
Yes, thank you, Mr. Halpern. Mr. Baker, you understood in connection with this contract that you had the responsibility to notify the contractor if you were going to make any changes in the work or stop the work. Isn't that correct?
Yes, I understood that.
And you understood, did you not, that the contractor had the responsibility for coordinating the work on the project?
Well, I knew he was in charge of the construction.
You expected the contractor, did you not, to organize the work to finish the job as quickly as possible?
Well, I don't know that. All I know is that I approved the schedule which he submitted.
Wasn't it important to you to have the work done on time?
Yes.
Indeed, wouldn't you have benefited if this building had been finished ahead of time?
Well, certainly not the way it turned out.
There was nothing in the contract to preclude the contractor from finishing ahead of time, was there?
Well, not that I know of.
That's all that I have.
Thank you, Mr. Madison.
And this witness concludes the testimony on behalf of the owner.
Thank you, Mr. Hogan. I understand that each of you has now put in all of the evidence orally and in writing that you want to put in, and that each of you rests. And accordingly, we'll take a break for a few minutes, and then after the break, you can all come back, and each of you can give a closing argument.
Thank you.
Mr. Halpern, we believe the evidence in these proceedings demonstrates the following. At the early stages of this construction project, the owner began to consider structural redesign. Indeed, this was while foundation work was just beginning. This fact was known to the general contractor. Pursuant to the agreement between the owner and the general contractor, a construction schedule was prepared by the contractor and approved by the owner. Had this schedule been followed, the structural redesign would have had no impact whatsoever on this project. That is, none of Meade Mechanical's work would have had to be redone. During the discussion between the owner and the general contractor concerning the job shutdown while this redesign work was finalized, the owner requested the general contractor to advise if any extra costs would be incurred. The general contractor never advised the owner of any extra costs, and indeed none were ever authorized. Since the contractor did not advise of any extra costs, any extra work done by Meade Mechanical or the general contractor should be for the general contractor's account. The owner should not be liable for any extra work done by either Meade Mechanical or the general contractor. Thank you, sir.
Mr. Halbron, you've heard Mike London testify that he and the mechanical subcontractor had started work and were proceeding in accordance with the contract documents when Mr. Baker stopped the project. Unfortunately, the stop work order came so late that it impacted work already in place and was impossible to avoid extra costs. Yes, the contractor was ahead of schedule, but time was of the essence, and it's a central feature of a lump sum contract that the contractor have the freedom to reorganize the work as necessary in order to achieve maximum cost savings. This is what gives the contractor the incentive to give the owner the lowest possible bid in the first place. Mr. Baker's position is totally without merit. He gave clear oral instructions to stop the work. He expected those instructions to be complied with. On previous occasions, when he had made oral changes, those were paid for. He had an obligation to notify the contractor of changes in the work in a timely fashion. He was at the job on a regular basis and could see the progress of the work. And Mr. London told him that extra costs would be involved in the changes in the work and the delays. Mr. London has correctly interpreted his obligations under the contract, and both he and the mechanical contractor should be paid for the extra costs incurred.
Okay, you've made your positions very clear, all of you, and I'm very grateful for that. I think I have them well in mind. I've taken a lot of notes here, as you've all seen. I'd like a chance to review them, and of course I want to think about it. But as to the time of the award, the AAA rules do require that an award be issued within 30 days, and it will be, and I'll try hard to do it before then. So the hearing is now closed, and thank you all very much.
So that concludes our look at an arbitration, and in the next segment we're going to explore the questions I raised earlier along with some additional questions. Let's analyze the questions that we asked during the last segment. First of all, how would you decide this case? When I ask this question in my class, there's usually a lot of debate, sometimes heated debate, and often the class is divided into three parts. Some people say, well, clearly the contractor and subcontractor should be allowed to recover from the owner. The owner made the changes. The owner knew that the changes were being made. The contractor has the right to complete the work ahead of schedule. A second third of the class say that clearly the owner wins because the owner never approved the additional expenses. And then a third group tries to split the bill. For instance, they might say, well, the contractor can recover $55,000 from the owner, but the contractor is liable to the subcontractor. So strong differences of opinion. Any surprises? The most surprise that people usually express is that they are surprised how legalistic an arbitration is. For instance, swearing in the witnesses, testifying under oath, the examination of the witnesses, the use of attorneys. That's why I like to refer to arbitration as private litigation. It's similar in many ways to litigation, although it is out of the public eye. Must the arbitrator be a lawyer? Well, this was covered at the very beginning of the video, and the answer to that question is no. One of the lawyers was explaining to his client that they were lucky in this case because the arbitrator was both an expert on construction law and a lawyer, but you could have either one. You are qualified to be an arbitrator if you want to. You do not have to be a lawyer. Must the parties be represented by a lawyer? The answer to that is no. You're free to go into an arbitration on your own. However, given the fact that this is a legalistic procedure, you might want to bring in a lawyer if the other side is bringing in a lawyer. And finally, is litigation procedure followed in arbitration? No, not necessarily. As this arbitrator pointed out near the beginning, the formal legal rules of evidence are not going to apply, and he would use common sense instead of those traditional rules. Here's an additional question. Is arbitration more expensive than litigation? Let's assume that we have a $600,000 construction dispute, and these cost estimates come from experts in Texas, Florida, and Pennsylvania. And my question to you is, in the $600,000 construction dispute, what cost more for filing the case and for the hearing and trial, including legal fees for the hearing and trial, but not other legal fees? Which costs more, arbitration or litigation? Please think about that for a second. You may want to write down your answer. Does arbitration or litigation cost more for this construction dispute? Here are the results. It costs $300 in these states to file the case in court, and cost $8,500 to file the arbitration claim. Legal fees would be higher in litigation than arbitration, but the cost of the arbitrator would be higher by almost $17,000. So the total cost for the filing, for the hearing, and for the arbitrator would be $49,000 as opposed to $36,000 in litigation, substantially higher in arbitration. Now, why is that? Well, it's because when you use the court system, generally you get free public goods. You virtually get a free judge, you get a free courtroom, and you get a free flag. Whereas in arbitration, you have to pay for these. Where the difference is, if you look at the total cost, litigation does cost more. And my guess is that that results mainly from discovery. Discovery is more elaborate, takes up more time legally in litigation than in arbitration. You can control discovery through your arbitration agreement. So keep these figures in mind when you're negotiating an arbitration clause in a business deal. One other very important point regarding arbitration is illustrated by this case. We've got a guy named Cam who threatens to shoot another worker, Bingham, and also other workers where he works in Palo Alto. These threats are considered a joke. Cam tells Bingham, "I can kill a man at 600 yards. Cam owns 18 rifles and pistols. He has a personalized license plate. Shoot." And one day, Cam and Bingham get involved in a workplace dispute, and Cam says, "I'm going to shoot you, I'm going to shoot your wife, and I'm going to shoot your baby." So Palo Alto, the city of Palo Alto, fires Cam. Case goes to arbitration. And the arbitrator says, "Look, this threat is just everyday boy talk," and reinstated Cam with back pay. Now, my question for you is that a final decision, or will a court interfere with that decision? Final or not? The answer generally is that is a final decision. According to the court, an arbitrator's decision is not generally reviewable for errors of fact or law, even when it causes substantial injustice. Now, Palo Alto said, but wait a minute, public policy requires us to have a safe workplace. But the judge said, well, that's true, but that doesn't mean you have to fire your employees. There was a happy ending here in that even though the arbitrator's decision was valid, there were separate reasons that resulted in a reversal. There was a separate injunction against CAM that came into play. But generally, the rule to keep in mind is that arbitrators' decisions are generally not reviewable for errors of fact or law. In other words, the arbitrator's decision, the arbitrator acts as the judge, as the jury, and as the Court of Appeals. And so there have been some major cases where this rule has come into play. Years ago, there used to be a firm called Arthur Andersen, which has since disappeared. And they had a consulting arm called Andersen Consulting, which is now known as Accenture. And Andersen Consulting broke away. And the question is, when they broke away, what did they owe Arthur Andersen? Arthur Andersen was fairly confident that they were going to recover around $14 billion in compensation from what came to be known as Accenture. But the arbitrator's decision was only $1 billion, and as this article notes, it cannot be appealed. That's final, even though it was way short of what Arthur Andersen thought it should get. Despite this finality of arbitration awards, according to this study, a significant majority of companies in Asia, Europe, and the Americas prefer international arbitration to resolve cross-border disputes. Corporations overwhelmingly favor the finality of arbitration awards. Although I sense there's increasing dissatisfaction with arbitration for other reasons, especially because it has become such a legalistic process. And as a result, many companies now favor mediation even more than arbitration. And in the next segment, we're going to look at mediation. We're now ready to look at the second key building block for ADR, which is called mediation. And I'd like to start with a couple of very short clips that will give you a taste of what mediation is like. And then we'll look at a longer clip that will allow us to analyze a business type mediation. So here is the first short clip.
I want you to cut down your horrible trees. I can't suntan anymore. Ugh, I just can't communicate with him.
Allow me. I speak argue.
Excuse me?
And here is the second short clip illustrating another mediation situation.
Hi. I'm your mediator.
I'm really glad we can be adults about this.
Now, we're going to turn in a minute to a longer mediation, again involving a contract dispute. And as you watch this mediation, I'd like you to consider these questions. First of all, how does mediation differ from negotiation? Second, what type of mediation is involved in this film clip? Is it evaluative, facilitative, or transformative? And finally, how would you rate the mediator on a scale of 1 to 10? Does she do a good job or not, and why? Before we start the clip, just a few words of background on on the types of mediation. Traditionally, mediation was considered a problem-solving process, and there were two fundamental types of mediation, facilitative and evaluative. With facilitative, the goal of the mediator was to facilitate conversation, discussion, and negotiation between the two sides to reach a settlement. With evaluative mediation, the mediator would do the same thing, except also would be asked to give an evaluation of the mediation to provide certain expertise. What has happened in more recent years is the addition of another type of mediation called transformative. And the goal of transformative is not necessarily to solve a specific problem, although that might be one of the results, but it's also to transform the relationship between the parties, to give especially one party who might lack power, might lack a voice, more of a chance to express his or her feelings. Here's an example of the use of transformative mediation. Huge organization, the U.S. Postal Service, at this time had 800,000 employees, and in 1997 they had 14,000 formal complaints with the Equal Employment Opportunity Commission. So in 1998 they started to use transformative mediation for these complaints. And these are the results over the first roughly 2 years. They resolved over 17,000 informal disputes. They had a 30% drop in formal complaints. They saved millions of dollars in legal costs and improved productivity. And the disputants, to a large extent, 90%, were satisfied with the process. Now, one of the problems with these studies is that it never gives you real-life stories about how this process might work. So I sent an email to one of the leading researchers on transformative mediation in the country, and I asked her to give me some flesh and blood examples of transformative mediation. And this is one of the examples she sent me. This is one of the postal cases. We've got a female employee, small, she's a letter carrier, files a sexual harassment complaint against her supervisor, claiming that he addresses her by her route number instead of by her name. When they get involved in transformative mediation and she's allowed to express her feelings, the parties realize that he addresses every letter carrier by route number. And he had no clue that people found this dehumanizing or offensive. He had no idea until the mediation that this was the reason for the sexual harassment complaint. He started greeting people personally, apologized for the past conduct, and the employee withdrew the complaint. So now we're ready to look at the video, and let me give you a little bit of background information about the video. This is a dispute between a company called Compuplast and PM Limited. Basically, Compuplast has agreed to provide robotic software to PM Limited. However, it looks like the delivery date will be delayed. And PM Limited is very upset because PM Limited produces door handles for the auto industry, and if they don't get this robotic software, they're going to lose a lot of business. So they cancel their contract with Compuplast, and both sides have threatened to sue. It's a very emotional, hostile environment for the mediation. One challenge that you have in watching this mediation, for those of you from the United States, is that the mediation is in a foreign language. It's in English. So try to do what you can to understand this British mediation. So again, these are the questions. How does the mediation process differ from negotiation? What type of mediation is this? Evaluative, facilitative, and transformative? And how do you rate the mediator and why? And with regard to that last question, remember that many of you will be serving as mediators and resolving disputes on the job or perhaps even in your family. So watch the techniques used by the mediator. I think there's some great learning watching her in action. So this is our mediation video.
And what about this headache? Let me introduce you to a robot. Its job is to make plastic door handles for cars. There's just one snag. The latest computer software needed to make the robot work hasn't arrived at the factory, PM Limited. The software designers and suppliers, Compuplast, have failed to meet a deadline, and their failure is leading to enormous financial difficulties, both for PM Limited and for the car company, which needs the door handles. Indeed, Compuplast themselves have a lot to lose. Once again, it looks like a dispute heading for court, thousands, perhaps hundreds of thousands of pounds in litigation costs, and the breakdown of a hitherto friendly and profitable business relationship. But does it have to be like this? Even as the lawyers are treading their expensive path up the courtroom steps, they know that there's a chance that the matter will be settled out of court. But in the meantime, costs to their clients have risen, sometimes frighteningly so, and that is no good to anyone. A financially undermined client is never a happy one. If you're a lawyer, then you might think, well, my client has contractual rights that need to be upheld, and if that means going to court, so be it. After all, costs might be recoverable down the line. But increasingly, that attitude is not being accepted by clients. They want to know if there are other ways of ensuring that they don't lose out, and if there's a way of keeping a business relationship going, rather than find relationships so soured by the litigation experience that a previously happy business partner now finds himself permanently at daggers drawn. This, ladies and gentlemen, is where ADR comes in. Let's consider the dispute involving a robot, a plastics manufacturer, PM Limited, a computer software firm, Compuplast, and a car company. Because of the delayed arrival of software, this robot isn't able to produce enough car door handles to satisfy the contractual arrangements entered into by PM Limited. They promised to supply the handles within a week. Because of Compuplast's failure, PM has cancelled a £500,000 order for more software from Compuplast, a move which could mean the end of the company.
I'd like to thank you all for coming this morning to help to try to resolve this dispute. My name is Elizabeth.
Compuplast has asked the mediator, Elizabeth Rivers, to see if there's an alternative solution to this dispute, one that won't lead to enormous litigation costs, and one which will help all parties reach a satisfactory solution. While their decision has led to round-table talks between PM and Compuplast, both of whom have brought along their lawyers. By watching this mediation process, you'll see exactly how ADR works. Elizabeth, a London lawyer, is a trained mediator. Her brief is simply to try to enable the two sides to reach a solution. The two sets of lawyers have been asked long to ensure that neither PM nor Compuplast make a legal fool of themselves. Let's follow the action.
Now, I understand that your lawyers have sent to CEDA the signed mediation agreement. I'd like just to clarify what my role is here today. Firstly, I want to stress that I'm not here to impose any sort of solution upon you, and I have no authority to make any sort of binding ruling. This is your dispute. I'm simply here to help you to try and arrive at your own solution and to facilitate communication between you. The process is entirely voluntary. You can leave at any time if you're not happy, and it's non-binding unless and until an agreement is reached. I'd like to explain a little bit about the procedure which we'll adopt this morning. Firstly, each party will have the opportunity to make a statement of their position, and they're permitted to do that without any interruption from the other side. And I'd like to ask you to hear one another out and not interrupt while the opening statements are being made. At the end of those statements, I will then attempt to summarise what you've said to me. After that, we'll break up into private meetings where I'll see you each individually with your legal representatives. And those meetings are an opportunity for you to speak to me as frankly as possible and in confidence about your concerns about this dispute.
Shortly, the two sides will speak separately to the mediator in so-called caucus meetings, which are entirely confidential. But first, the opening statements.
As Compuplast have called me in as mediator, I suggest that Miss Carter make the first opening presentation.
Okay. Right, well, Compuplast is a small computer company. We produce computer software in the in the plastic moulding industry. Last year we were approached by PM, Mr. James, and asked to design a program of software to enable him and his company to speed up the robot-controlled plastic moulding system. And at considerable expense to us, we did design a range of software that could do this, and it seems set to revolutionise the industry. On the strength of this success, PM have come back to us and asked to design more new computer software. But they also came back and asked us to modify the original software, which we agreed to do. They set us a deadline, which unfortunately, due to unforeseen business circumstances, we can't reach. Now PM have threatened to withdraw their orders for the software. Should they do that, we've got no option but to sue. Our investment was based on their orders. We think we'll succeed in an action against PM. We know that we can provide the modified software they want, but we need more time. Because PM asked for those modifications, it's their fault there's a delay and not ours. We think that it's all PM's fault.
Mr. James, would you like to make your presentation now?
Yes, certainly. We're a plastic moulding company producing parts for the automotive industry. Quite recently we won a very large contract to supply a major car producer with outside door handles. We gave a contract to Compuplast to design the software for this system. They totally failed to meet the deadline. This means we cannot supply parts to our customer. The result of all of this is the fact that, first of all, we'll certainly lose the current contract. It's doubtful we'll ever get a contract again from our customer. And thirdly, the worst case, they will probably take us to court and sue us. This is a result totally of Compuplast's incompetence and inability to meet the deadline. Our position is quite clear. We've cancelled orders for software from Compuplast. There's no guarantee they're going to meet future deadlines. Furthermore, we'll take Compuplast to court on the basis they're in clear breach of contract. They must know this position they're in. It's quite serious, and their abject failures place us in an intolerable position.
Thank you for those presentations. I'd now like to have a caucus with Compuplast. So perhaps Mr. James and your lawyer, Mr. Barra, could step outside and wait in the adjoining room.
The mediator has heard Compuplast's public position. She understands that posture, but how privately do they assess their position?
In your opening presentation, you said that you would be able to provide the software, but simply that you couldn't provide it within the deadline set by PM.
Right.
Realistically, how quickly do you think you can provide the software?
Well, probably within 10 days of the deadline, I would think.
Right.
We could probably produce it within the deadline if we had some more help, if we could employ more staff.
But I also must counsel you that really we have to be cautious about tying deadlines until we're quite sure of the work involved.
You know, we feel that we've gone out of our way to help them, and if they want us to meet this new deadline they've issued us with, then they've got to help us.
Yes, I think we haven't actually reached that deadline yet, and really Miss Carter's been very good by advising them of the problems before they actually take place, and we'd hoped that we might get a better hearing and a little bit more tolerance.
Yes,
I thought Mr. James was very emotive, you know, in his approach, and that was a little bit distressing.
Yes, certainly we didn't expect them to automatically threaten to sue us. It was very, you know, I think they went completely over the top.
Yes, I mean, we hoped that he would actually help us help him.
Right, well, I'm pleased to hear that you think you can meet the deadline. You mentioned that you would need assistance from PM. Can you be more specific about precisely what you would need?
Well, I've talked to you about this, Nick. I mean, really, our problem is, and I would prefer that you didn't disclose this to them, is that we actually need money to employ someone. We just haven't got sufficient money to hand to be able to employ the sort of person that we need at such short notice. We just haven't got it. So if we're going to be able to meet this deadline, then we need some help financially to employ the quality of staff needed to produce this software. We might even need 2 people, so we're talking at least 25,000, I would think.
Right, I see. So, to summarise, without any extra assistance, you think you could provide the software, but it would be 10 days after the deadline which has currently been set. However, if you were able to employ additional staff, you think you could still meet the deadline. But you don't have the funds, if I'm correct in saying you don't actually have the funds at the moment to employ an additional staff, so you would need some sort of injection of cash to do that, and you'd be looking in the region of £25,000. Right. Is there any way that PM could help you with your cash flow, for example, by making some sort of accelerated payment?
Well, I think, yes, they certainly could. If they could give us 25,000 now, then we'd be happy with that, and then the remaining payment at the end of the at the deadline. Yeah.
Right. Can I confirm with you that I'm authorised to disclose that to PM?
Yes, I don't think that would prejudice our position.
Thank you. I'd now like to talk to PM privately.
The mediator's probings have identified the potential for a settlement, but will this match PM's aspirations?
Well, the way I feel at the moment is they created this problem and I'm prepared to go all the way to the courts to sort it out.
Right.
I don't feel like compromising at all.
I see. I've no doubt that you've discussed with Mr. Barra, your solicitor, what the likely outcome would be if you went to litigation.
The mediator has a difficult job on her hands. At this point, PM and their legal advisors discuss the reality of a complex court case.
You said in your opening presentation that if you don't meet the deadline for your car supplier, that you will lose that contract, future orders, and possibly also be sued by the car manufacturer.
Yes.
Now, realistically, do you think there is any flexibility with that deadline?
I don't think there's any flexibility with the deadline at all now.
Right, so it is crucial that deadline is met. Right, I see. What Compuplast have said to me is that they could meet the deadline, but that they need extra staff to do that. Now, it seems to me that it's probably in your interests, whatever the rights and the wrongs legally in this case is, to try and work together with Compuplast to meet the deadline if possible.
Well, I think if they need more staff, that's really their problem. They committed to a deadline. It's their problem how they achieve that deadline, not PM's.
Certainly I can see that as a matter of contract law that's the case, but I think given the knock-on effect of their inability, it seems, to meet the deadline at the moment, effectively it becomes your problem as well. So I think the spirit really of mediation is that everybody tries to work together to arrive at a solution to this problem.
I share your concerns as well. I mean, here we have a company, in fact, that contracted to deliver a product at a particular time, and then time of the essence was made plain in that particular contract.
Okay. What sort of figure are they talking about?
Well, what they've said to me is that in order to meet the deadline, they need to take on some additional staff. And they're looking at a figure in the region, say, of £25,000.
It would concern me, actually, if we've already contracted for them to deliver a product and they haven't been able to meet the deadline, and yet they want another £25,000 from my client.
I can see, obviously, that you do feel very strongly about this, and I can see that this has caused you a very serious problem for your business. And,
certainly has.
The loss of goodwill with the car company is obviously very serious. So I do see that.
Okay, we'll give it some consideration then.
Right. So you will check the contract and see what payments are outstanding.
Yes.
Several hours have gone by. The mediator has established that PM owes Compuplast £18,000. That could be released immediately. A range of other possibilities are also discussed. What was a legal argument has become a commercial negotiation. Through subtle diplomacy and direct bargaining, an imaginative solution is reached, one which avoids the court.
I've called you all back together because I think we've now been able to reach an agreement. I'd like to summarise the terms which have been agreed. Firstly, PM will make an immediate payment to Compuplast of £18,000 in respect of its unpaid invoices. Secondly, there will be a meeting in 1 week's time between PM and Compuplast to monitor the progress of the development of the software. If PM is satisfied that the deadline will be met, then they will release a further £7,000. In addition, PM's software license from Compuplast is to be extended for a further 2 years at no extra cost. And finally, if PM place any further orders in the future with Compuplast, they will have a 10% discount. Does everybody agree that I've accurately summarised the terms of the agreement?
Yes. Yeah.
I'll now write those terms out, and I'll ask you all to sign it, signifying your agreement.
Okay. Can we agree a meeting now?
Certainly, yes. If you want to fix a date now, yes, that's fine.
So that's the way the system works.
In the next segment, we'll look at the questions I described earlier, as well as some other matters relating to mediation. Let's now look at the questions we posed regarding the mediation video. And the first question is, how does the mediation process differ from any other negotiation? What was your answer to that question? When you look at the mediation process as illustrated by the video, it opened with the mediator stating the ground rules. Then we had opening statements by the parties. We had a search for interests and options, in other words, trying to get beneath positions to underlying interests. And then we had closure. So in many ways, that looks like the basic process for a negotiation. However, there is one major difference, and that is in the mediation, the mediator uses a caucus where she met privately and confidentially with each party to find out whether they had any private concerns or private interests they did not want to express to the other party. Think of how powerful that is. Because the mediator can talk privately with each side, in a typical negotiation, she can ask them, what's your reservation price? She can look at what they think is reasonable. She can do an analysis and, in effect, construct a zone of potential agreement between the two parties that's impossible to do without a mediator. And in some cases, the mediator might say right at the outset, well, look, there's no way you two will ever reach an agreement. Let's go home and forget about it. In other ways, she might find, in other mediations, she might find there's a large zone of potential agreement and work to construct a settlement or an agreement. So the use of a caucus is an especially powerful tool. Of course, the other main difference is you've got a third party there to mediate and to try to control the emotions of the parties. Our other two questions: what type of mediation is this? Evaluative, facilitative, transformative. What did you answer? What type? Well, it's not a mediation that's focused on transforming a relationship. It is a mediation that's focusing on solving a specific problem. So it's not transformative. It's either evaluative or facilitative. Was the mediator asked to provide evaluation of the results? No. And therefore, this is a facilitative mediation where she's trying to encourage the parties to work together to come up with a constructive solution. Just as an aside, if you do decide on an evaluative mediation, obviously that will affect your choice of mediator because you want somebody who has the expertise to conduct the evaluation. And then finally, how would you rate the mediator in this situation on a scale of 1 to 10, where 10 is the highest value? Normally, when I ask my students this question, they give the mediator a very high rating for a number of reasons. The mediator, for example, was very good at what's called active listening. She not only listened, but she was able to reframe what the parties said. She was also very good in suggesting options for the parties to consider. And finally, she was very good at something called reality testing. when one of the parties talked about going to court, we've got a great case, we're just going to sue. And she used active listening and said, yes, I understand what you're saying. You could go to court. You have perhaps a good case, but think of what that's going to cost you. And think about whether that will solve your problem, which is getting the robotic software. In effect, the other side's problem is also your problem. Why don't we work on solving that problem rather than going to court? So very good on reality testing. So overall, I agree with my students. I think this mediator did a great job. And by watching her, I think you can develop some techniques that you can use when acting in a third-party role, trying to resolve disputes among employees or among family members. I belong to a listserv of mediators. And what I found over the years is that mediators are very much like this mediator. They're very friendly. They're very open to problem solving. However, a while ago, one of the mediators on this listserv lobbed a hand grenade into the listserv. This is what this person's message said. Get me off the effing list. Now, for those of you outside the United States, I'm not sure if you understand the word effing, but it's not a polite word to use. So when she lobbed this hand grenade into the listserv, I was curious as to how people were going to respond. And the first response was sort of what I expected. What I hear you saying is that you wish to leave the list, you've misplaced your information about how to do so, you're a tad frustrated and would appreciate somebody's help. But the next message went on the attack. Other approaches are preferable to you profanely demanding that others make up for your lack of diligence, skill, or wit. Thanks much. The next person went on the attack against women in general. The obscene language used by women constitutes one of the double standards men must endure today as the price for collectively having oppressed women in the past. Women today have complete discretion over whether to use colorful language. If men use it in the presence of women, this constitutes sexual harassment. And then finally, the last mediator brought it to a close, came full circle back to what I expected from mediators. I ask and urge all of us to let this go. As I mentioned earlier, many lawyers are not enthusiastic about ADR. They're not enthusiastic about mediation. Here's an example. This is Joe Jamail. I don't know if you remember that name from our earlier discussions in this course. Joe Jamail was the person who won the $3 billion award for Pennzoil against Texaco. He had a lawyer's fee of $400 million in that case. This is his view. I'm a trial lawyer. I try cases. There's some lawyers who do nothing but this mediation bull blip. For those of you from outside the U.S., you can probably guess what that is. Do you know what the root of mediation is? Mediocrity. So you do run into this view from lawyers. By the way, there's sort of a private joke that in law firms, ADR, instead of standing for alternative dispute resolution, stands for alarming drop in revenue. But here's the view from another lawyer. And I'm going to ask you a trivia question. Can you guess who this lawyer is? My joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties. The lesson was so indelibly burnt into me that a large part of my time during the last 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, and certainly not my soul. So trivia question, can you guess the name of this lawyer who, especially during the last 20 years of his law practice, spent a lot of time with mediation? I'll give you a big clue. I think he would be probably on everybody's list as perhaps one of the top 5 leaders in the 20th century, one of the top 5 human beings of the 20th century. Any guesses on the name of this lawyer? His name is Gandhi. So that concludes our look at mediation, and in the final segment, we'll look at how you can review the success of your contract performance and evaluate that success. We're now ready for the last segment in the unit on performance and evaluation. As mentioned earlier, if performance goes well, there's really nothing to discuss. So our focus is on where there is a problem with performance, and we started by looking at how to prevent disputes relating to contract performance. And then we looked at concepts and tools that relate to alternative dispute resolution, along with a deep focus on the 2 foundations, arbitration and mediation. So we're now ready for the last step, which is a look at reviewing your performance and evaluating the performance. Let me start with a quick story relating to review of contract performance. Several years ago, an international consulting firm contacted me, and they told me that they were having major problems with contract performance. What basically happened is that one team from this consulting firm would negotiate contracts, and then another team would enter the scene and work on performance. And because of the performance issues, the so-called engagement team had to do a lot of contract renegotiation. And so the consulting firm asked me to come to Paris to meet with their consultants and to conduct a seminar on contract renegotiation. Well, when they contacted me, I heard the word Paris, I heard the word springtime, and I quickly said yes before I thought deeply about what I was going to teach, because fundamentally a contract renegotiation involves the same issues as a contract negotiation. And so I wondered if I would be stuck with simply repeating concepts related to contract negotiation. As I thought about this more deeply, I decided to contact the leaders of the consulting firm. So I sent email messages to the leaders who are based around the world. And I asked them to tell me what they thought the problem was, why there was so much renegotiation. And this is typical of the response that I received. This is from one of the emails. More often than desirable, the persons responsible for original contract negotiations are only responsible for obtaining the contract and not for its implementation. The incentives are more linked to closure of the negotiation than to ongoing implementation. So I discovered through these emails that there's a fundamental tension between creating a contract and then performing it. And so with this analysis, I was able to focus on how to deal with this tension when you review a contract. And I found an outstanding article by Danny Ertel, who discusses this issue. The article's called Getting Past Yes. It's in the Harvard Business Review. And in the article, he talks about the deal-making mindset versus the implementation mindset. Deal makers use surprise to gain advantage, whereas folks focusing on implementation would like to raise all issues as soon as possible to allow a thoughtful response. Deal makers hold back information, implementers share information to increase trust. Deal makers use tactics such as false deadlines to close deals, whereas implementers spend as much time as necessary to develop an agreement that works. Deal makers try to protect themselves with penalty clauses. Implementers focus on developing commitments that are realistic. And so this article and this summary, I think, provides a great tool for situations where there's a conflict between the deal makers and the implementers. It's a great way to review performance and ask, are we in a deal maker mindset or an implementation mindset? Now, in fact, even when there aren't two separate teams, all of us have two mindsets when we negotiate. The left-hand side is basically the positional mindset that we talked about earlier. The right-hand side is more of an interest-based mindset. So this is a great tool even when you don't have two separate teams. Now, beyond this question of the conflict between the teams, there's a more general question of stepping back from any negotiation and doing an evaluation. And Ertel wrote another very useful article, again in the Harvard Business Review, in which he contrasted negotiations that focus on deals, a deal focus, versus a larger picture focus. And here again, you can see that on the left-hand side, the focus is more position-based, on the right-hand side, more interest-based. So the deal focus would focus on things like price discounts, whereas a big picture focus would look at the total cost of ownership, including reducing defects, supplier efficiency, and developing new products. A deal focus would look at the number of sales. A big picture focus would focus more on the length of customer relationships, referral business from the customer, innovations from the customer. The deal focus adopts the mentality, well, we've never lost a customer, where the big picture focus would instead look at the deal that was made and contrast it with your BATNA. And the deal focus would only review deals sporadically, whereas the big picture focus would have a systematic review and improvement of process. So again, another great tool for evaluating your negotiations when you've finished. Did you use a deal focus or a big picture focus? One last point here, and that relates to systematic review and improvement of the process. There are a number of management tools that enable you to do this. Let me just give you one example. At Becton Dickinson, the attorneys used a Six Sigma process for improving contracting. It started with definition, a process map showing the steps in their negotiations. And then they did measurements. How many hours did it take to complete negotiations? How many hours for each step? And then they did an analysis. And what they discovered in the analysis is that if the entire Becton Dickinson team was involved, then the negotiations were shorter. The problem was the members of the team were working on side negotiations along the way that delayed the process. And then finally, they did some improvements. They charted responsibilities for each stage of the process. And the results were fairly dramatic. They reduced negotiation periods by about 65%, and they concluded that a large company like this could quickly arrive at productivity improvement equal to millions of dollars. So these are some considerations when your business is reviewing negotiations, but I strongly recommend that you also do a personal performance review whenever you're involved in any major negotiation. And in that personal performance review, simply ask yourself, what did I do well? And how can I improve? I also recommend that you develop a negotiation diary where you chart your results in various negotiations. That will help you identify areas for improvement down the road. Here are some questions to ask in your self-assessment. Did I work hard at establishing a relationship at the beginning? Did I search for underlying interests? Did I ask questions and listen carefully to the answers? Did I find out very early on in the negotiation whether the other side had authority to do a deal? Did I use an effective first price strategy, as we discussed earlier in this course? Did I look at the negotiation from the other side, that element that separates great negotiators from good negotiators? Did I use reciprocity when trading interests? And did I keep a big picture perspective? So that concludes our look at performance and evaluation, the end game, I want to leave you with one last thought that I think is very important. And this thought originated a few years ago when I gave a talk at the annual meeting of the American Bar Association in San Francisco. And I felt very honored that they paired me with another speaker by the name of John Wade, who I think is probably the best mediator in the world. He's a practicing mediator, but his writings are also fantastic. And during his talk, John mentioned a life goal analysis that he uses for dispute resolution. And let me give you an example. This is a situation that he used. We've got a battle between a husband and wife that are going through a divorce. They're members of the Chinese community in, I think he said, Sydney, Australia. John is from Australia. So the husband, 45 years old, the wife, 36. The husband has a large income and lots of assets. The wife has small income and relatively few assets. The husband is a prominent physician. The wife runs a small shop. The husband has many supporters in the Chinese community, while the wife is isolated within the community. So they go through very emotional, positional negotiations, and they divide up their property, and they're down to the last 40,000 Australian dollars. And they just can't seem to reach an agreement after this very hostile negotiation. So they brought in John as a mediator, and he asked them both to step back and think of this negotiation in terms of their life goals. The wife agreed to do this exercise. The husband refused. So what I'd like you to do is put yourself in the position of the husband. If you were the husband here, what life goals might you think about to try to put this specific negotiation in context? Please press pause for a second and write down what you think the life goals of this physician might be. Well, when I did this exercise during John's talk, I thought of a number of goals. I thought, well, he wants to increase his assets. He wants to increase his position in the medical community, maybe head a medical center, maybe be named to a professorship in medicine, maybe head a medical society. Perhaps he wants to develop a new relationship with somebody else. Perhaps he wants to enjoy life as he becomes older and has worked hard throughout his life. You can think of a number of life goals that he might have adopted. What happened here, as I mentioned, he did not do that. Eventually, the husband and wife ended up splitting the 40,000 Australian dollars, and it came time for their court hearing. Picture the courtroom. We have the wife sitting on one side with a couple of her friends. She was, again, isolated in the community. We have the husband on the other side with a large group of his friends. Some of them ridicule the wife, ready to celebrate, ready to go out to a fancy dinner after the divorce is finalized. So the judge finalizes the divorce. The husband and all of his friends leave in a very jubilant mood. They go out of the courtroom, turn right, and head down to a fancy restaurant. The wife walks out of the courtroom by herself, and as she walks out, she turns to the husband's attorney and says, "Now it is time to get even." She walked out of the courtroom, turned left, and walked down to the offices of the medical society. She walked in and asked, "Is this the place where I can file a complaint against a physician?" And they said yes. She said, "I'd like to file a complaint against," and then she named her husband. And she said, "Number one, he performed an illegal abortion on me. And number two, he has been sending drugs illegally to his relatives back in China." She filed the complaint, and that destroyed the husband's career. So when you think about this dispute within the context of your life goals, a relatively minor dispute in light of those much bigger goals, it gives you a perspective, probably would have been a good exercise for the husband to complete, and he didn't hear. You're going to have finally a chance to practice what we've talked about in the course. You will be negotiating an exercise called the House on Elm Street. And here is the common information from that exercise. This involves negotiations between Tracy and Pat. One of you will be Tracy, your counterpart will be Pat, for the sale of a beautiful old Victorian house on a large lot in a residential neighborhood. The house needs expensive repairs. The seller and neighbors have a strong interest in preserving the house and the neighborhood. The last sale in the neighborhood was 6 years ago, when a similar house sold for $135,000. The house was similar, but it was well maintained. Property values have appreciated considerably since then. And the property has a tax assessment of $140,000. But tax assessments are usually well below market value. So I want you to find somebody to negotiate with. It could be somebody you know in your own community. You could reach out to somebody across the world taking this course. Select one role, the other person will select the other role. Only read your own role. Do not read the role of the other side. Make sure you understand the facts in detail. There are only 2 pages, but there's a lot of detail on those 2 pages, so make sure you understand the facts. And you'll have 1/2 hour for the negotiation. Please limit yourself strictly to the 1/2 hour. You'll see some other instructions on the front page of the 2 roles. For example, negotiate as you would in real life. This is a real life scenario. Do not say something like, well, the role says that I'm supposed to say this. Just say it. Do not change any facts in your role. Stick strictly to the facts. And if you're able to reach a result, then be sure you note your results, because we'll be discussing them in the last unit. Not all of you will be able to successfully resolve the negotiation, and that's fine. Just stop after 30 minutes. After we debrief, after Unit 5, you will have a chance to, number 1, do your own negotiation performance review, your self-assessment. But unlike real life, you will also have a chance to assess the other side. In real life, when you negotiate, nobody ever says to you, gosh, you did a great job in this negotiation, but you could have taken a lot more of my money if you would have done X, Y, and Z. A good negotiator instead will say, oh, you did a great job in this negotiation. You really ate my lunch. You're the greatest negotiator ever. They'll never tell you how to improve. So this is your one chance to get honest, candid feedback from the other side. Please take advantage of this, and by the same token, please give honest, candid feedback to the other side. What did they do well? How can they improve? I use this approach in my class, and it's an especially valuable feature of the class. I receive many emails from former students who talk about it. Let me give you a couple of examples. Negotiation is a fundamental skill that we need to learn how to use. I was a bit hesitant to join the class initially, as I thought I had excellent negotiation skills. However, when I was put in a class with better negotiators, things were put into perspective and made me realize there was a lot to learn. The key difference is that in class, I got feedback and know what I did right and wrong, while in real life, I don't know if I could have done better. For example, as a management consultant, I negotiated a 55% raise 6 months before my review. My boss never told me whether I could have pushed for 60%, 70%, even 100% raise. Maybe I did fine, but I will never know whether I did right or wrong, or if I had maximized my raise. The class also gave me a scientific, conceptual framework which provided a significant level of discipline into what is stereotyped as an artistic skill. This is a critical tool that MBAs need to learn, not just to negotiate, but also to diffuse stressful situations. I've actually had former students who also bring this into the workplace. One of my students was the president of a car company in a specific country. It happened to be Mexico. He was president of blank company of Mexico. And he later was promoted and became the head of labor relations for the entire company worldwide. And he told me that he liked this model so much that when they planned their union negotiations, every Friday his team would meet, they would do a negotiation, and then they would use this kind of assessment to evaluate the results. So that wraps up this unit, and very important, before you start the next unit, please complete your negotiation. One final point, if you're negotiating with somebody who hasn't taken the class, give them a briefing of the kinds of questions they should think about in preparing for the negotiation and the kind of tactics they can use during the negotiation. I think research shows that the way we really learn a topic is when we teach it to somebody else. And so not only will you be helping them, but it will help you internalize the concepts that we've been talking about. So that ends Unit 4.